In this unit, we consider two related questions. First, the extent to which constitutional guarantees are enforceable directly against individual persons, and second, Congress's power to create statutes enforcing constitutional guarantees. Remember that the Constitution establishes the basic structures of government and, particularly in the Bill of Rights and the post-Civil War amendments, provides guarantees to individual citizens relating to actions by the government. The Bill of Rights concerns rights of individual citizens against the government, and the 14th and 15th Amendments protect individual citizens against certain actions by states. If the government deprives you of life, liberty, or property without due process of law, there's a constitutional violation. If another person deprives you of life, liberty, or property, you might have a claim under private law. In tort, property, or contract, there might be criminal culpability, or there might be some regulatory penalty, but usually there's no constitutional violation. The 13th Amendment makes slavery and involuntary servitude illegal except as punishment for a crime which reaches private conduct, but the amendment seems primarily directed at state laws that otherwise would legalize slavery. This principle is summed up in the concept of state action. There's no possible constitutional violation, except perhaps under the 13th Amendment, without state action. As we'll see, however, the concept of state action can become fuzzy when the government's regulation of or involvement in some area of otherwise private conduct is pervasive enough to suggest that otherwise private conduct really is a form of state action. Congress's power to enact legislation to enforce constitutional rights seems like it should be clear. The 13th, 14th, and 15th Amendments all grant Congress the power to enforce those amendments through legislation. During the Reconstruction era, Congress enacted civil rights statutes under these provisions in 1866, 1870, 1871, and 1875. Many of the provisions in those early civil rights statutes remain in force today. However, Congress's ability to enforce these amendments depends on the scope of the amendments themselves. If Congress passes a statute that purports to enforce the 14th Amendment against individuals without state action, that statute could be subject to challenge. This was precisely the issue in the 1863 civil rights cases. Section 1 of the Civil Rights Act of 1875 made it a misdemeanor to deny a person access to facilities such as inns, transportation, theaters, and other places of public amusement on account of race, and imposed civil penalties for violations. Private persons and companies who had been convicted or sanctioned for denying African Americans access to hotels, theaters, and railroads challenged this part of the statute. The court, in an opinion by Justice Bradley, struck down this provision because the 14th Amendment does not invest Congress with power to legislate upon subjects which are within the domain of state legislation, but to provide relief against state legislation or state action. According to the court, civil rights protected by the Constitution cannot be impaired by wrongful acts of individuals. Justice Harlan dissented because he believed the majority opinion was too narrow and artificial. According to Justice Harlan, the 13th Amendment shows that the post-Civil War amendments were designed broadly to remedy the effects of slavery, including effects caused by private conduct. Further, Justice Harlan suggested, industries like rail lines were heavily regulated, and thus there was at least some degree of state action involved. The holding in the civil rights cases, together with the holding in Plessy v. Ferguson, facilitated the state Jim Crow laws in the South that legally encoded racial segregation and other discriminatory conduct by private enterprises. Remember that the scope of the Commerce Clause was at best unclear prior to the New Deal era, so it was not immediately evident that Congress could enact federal civil rights laws using the commerce power rather than invoking the enforcement clause of the 14th Amendment. By the time the Civil Rights Act of 1964 was enacted, the court had interpreted the Commerce Clause quite broadly, so Congress could assert a power to reach private discriminatory conduct outside the confines of the 14th Amendment itself. Continuing debates about federalism and the Commerce Clause today, as much as they also concern issues about the costs of federal economic regulation, also play out against the backdrop of whether the federal government has the power to enforce civil rights principles against private enterprises, or whether this function is solely the province of state police powers.